as carol arrangements by Paul Mans and Marcel Dupré. Rockefeller Chapel is at 5850 South Woodlawn in Chicago. Plentiful parking on the Midway. For more information, visit rockefeller.uchicago.edu. Chicago Shakespeare Theater's must-see season continues with artistic director Barbara Gaines' production of The School for Lies, a deliciously off-color tribute to Moliere's comedy The Misanthrope. Set in a glittering world of glamour, gossip, and scandal, this scintillating adaptation by David Ives stuffs a 17th-century farce full of saucy contemporary slang with results worthy of a Baroque reality show. The School for Lies is now playing through January 20th. And beginning December 18th, renowned British actress Miriam Margolyes brings 23 of Charles Dickens's most colorful and entertaining characters to life in Dickens's Women. Best known for her roles in the Harry Potter film series and Baz Luhrmann's Romeo and Juliet, Margolyes gives a tour-de-force performance during this unique glimpse into the real life of Charles Dickens. Dickens's Women plays December 18th through the 22nd, 6 performances only. For information on The School for Lies and Dickens's Women, call 312-595-5600 or visit chicagoshakes.com. Exploring Music with Bill McLaughlin is next on 98.7 WFMT Chicago and WFMT.com at 7 o'clock.
Hello there, and welcome to Exploring Music. This is Bill McLaughlin. Our theme this week is the symphony. We've been browsing around, finding these wonderful pieces beginning in the early 17th century and making our way toward the end of the 18th century to the tremendous accomplishments in symphonic form of Haydn and Mozart and Beethoven. In the 20s and 30s of the 18th century, the symphony became tremendously popular, although it wasn't always the sort of deep emotional and aesthetic experience we might like to imagine. One of the popular places for symphony concerts was called an academy, which was actually a private concert given in a palace or a monastery or some private residence if someone had a throne room, for example, that was large enough for an orchestra. And these very often featured tea parties and card playing. In fact, as late as 1799, the Duchess of Brunswick was insisting that her orchestra always play softly when she was present so that the card playing wouldn't be interrupted. Of course, there were other places for public concerts which ranged from ale houses and coffee houses to actually rather formal concerts. Let's hear an example from a composer born in Bohemia, 1708. His name is Anton Wilhelm Zolnitz. We'll notice that this is Opus 3, number 4, which means he's writing a lot of symphonies.
Good evening. This is the meeting of the Evanston Plan Commission. We have a quorum. Several other members are expected to arrive, but are not here yet. First order of business is the minutes of November 14th. Our last meeting. Is there a motion to approve or correct?
Motion to approve.
Is there a second?
Second.
Any discussion? All those in favor say aye.
Aye.
The minutes are approved as written. That brings us to the zoning map and text amendment. 12 PLND 0069. And this is a map and text amendment concerning an proposed overlay district on Howard Street. Does the staff wish to comment?
Following the last Plan Commission meeting, the commissioners suggested that staff should readdress the amortization issue, as commissioners were not comfortable with that. Staff is now proposing the Howard Ridge overlay district that would still follow the TIF district boundaries and would have the same general concept. However, there would be no amortization for existing businesses there. They would be considered legally non-conforming and be allowed to remain within the overlay district.
And for the record, I assume the general legal non-conforming provisions of the ordinance would apply.
Correct.
Any other changes?
That is the only change.
Is there any discussion?
I just want to be sure I understand this. So if you're there now, you can stay.
Correct. As long as the use at a specific site does not cease for 12 consecutive months, then that use could continue to exist, or a new use could come into that same site.
So that the non-conforming, the special use requirement kicks in if an existing use is inoperative for more than 12 months, or a new use is proposed, a new site use is proposed.
Correct.
Thank you.
I wasn't here for the last meeting, but I remember that what brought this to the table was Alderman Rainey's concern about the continuation of businesses that were sort of businesses, maybe not businesses. And isn't there any way to address that is consistent with whatever rules we're governed by? I mean, I just hate to see this go away so quick.
What go away so quick?
It's not going away quickly.
At the last
That's
meeting,
the problem.
there was a discussion of this. A larger number of commissioners were present, and it was the overwhelming consensus that it seemed unfair to not allow those uses to be treated, to require those uses to get a special use to stay in business. So there was a motion to send it to staff to see what they suggested, and they came back today.
Essentially, the amortization leaves it up to the city whether or not a business can stay in business. And I would say,
well, it was
all of us.
It was a short amortization period.
It was 2 years. So within 2 years, you either get the license to stay in business, or Evanston closes you down. And a bunch of us, or most of us, objected to that 2-year amortization, or either any amortization or one that was so short.
I don't think that's the concern I have. Isn't there anything else? I guess that's really what I'm asking, to address it aside from the amortization issue or vehicle.
I think other than that, people were pretty satisfied with what had been proposed. I may be speaking out of turn, and others may have comments, but I think it was the amortization that had people not happy. Mr. Ford?
Certainly the amortization was a huge problem. This one still feels to me as though we're trying to drive a square peg into a round hole. We're trying to solve what is, I think, essentially a matter of business regulation by zoning. Maybe if all of these businesses were successful, we would still think there were too many. But my sense is that we are penalizing them for being unsuccessful. And I'm not sure that's a zoning issue. Given that we've defined this as a zoning problem, I think what staff has brought us is probably the best we're going to get. But
I didn't see that they were chosen because they were unsuccessful. Given the restaurant failure rate, which is probably greater than these businesses in Howard Street.
I think what I'm saying, Scott, is that if all of these businesses were successful, if these were all 9 in the morning to 9 at night, drawing foot traffic, paying business licenses and property taxes and all of those good things, I wonder if we would be as concerned. I walk many days through the Central Street between Lincolnwood and Central Park, and there is close to an overconcentration of financial services people in there, real estate and brokers and such like, but they're all successful, so we don't trouble them.
You think the cumulative impact is the same with financial services as these businesses?
As these businesses? Mm-hmm. No. I'm not sure what the cumulative impact would be if all of these businesses that we're regulating on Howard Street were successful. That's what I'm saying.
Other comments? I think, Seth, you were...
I understand wanting to regulate business. I objected to the amortization. I understand not wanting to have a concentration of any business, including too many banks and financial institutions. As you know, when we were on another subject concerning too many banks in Evanston, I thought we didn't need any more. So I think that perhaps we had talked about, I was actually surprised, and I guess it's part of the ordinance, that we allow 12 months. I thought by putting a special use, and that if the business goes out, that another one can come within 12 months, I thought was being generous, but apparently that's part of the ordinance. I don't know if there's any way around that, because I think if you don't get rid of that 12 months, I think you're going to remain with the same issue of just having hair salon after hair salon after hair salon opening up on that or an astrologer or whatever on those locations. I'm much more comfortable with this than my big issue was putting a business, successful or not, out of business because Evanston deemed that you can't be there anymore. I just didn't find that was. I found that objectionable, as did you, and as did others. So I don't have as big of an issue with this, what's come back, because I do agree if there was a way to manage the type of businesses that go into Howard Street, it would be a good thing. I don't know whether this will do it, but those are my comments.
Any other comments?
Well, we did take a stand on payday loans and tattoo parlors, did we not?
But that was
And we also,
all of Evanston,
yeah.
correct? Yeah. That wasn't just an overlay.
And did we put in a distance requirement for those?
I don't remember.
We did.
I think we did. Mr. Steele, the ordinance that we sent back to staff because of objections to the amortization provision has come back without an amortization provision and is otherwise the same, and that's what we're discussing. We may have some people in the audience who wish to comment on this.
Are aldermen allowed to speak at the
Absolutely. You are welcome to speak. Please. We recognize Alderman Rainey.
My name is Ann Rainey. I'm the alderman of the ward that Howard Street is in, the entire length of Howard Street on the north side of the street. On the south side of the street is Chicago. Chicago has one beauty shop, hairdresser, nail salon, etc., because they do not allow them. We have anywhere from 11 to 15, depending on what day you go down the street. Half of them are basically inoperative. In other words, they're really not functioning, but there are still people in there. I'm not really providing hair service, and I know that because I go there and check with them. I have no interest in putting anybody out of business who is currently operating a beauty shop, hair salon, nail shop, braiding, or any other personal service between Ridge Avenue and the CTA tracks. None. I disapprove totally of the amortization issue, putting somebody, forcing them into a special use after 2 years of full successful operation. What I would like, because if you take that out, and I don't think it should be in, but if you say that the special use goes with the property, then if we have 11 beauty shops today, we will have 11 beauty shops in 11 years. What I am asking is if a business goes out of business, because there's only one beauty shop on Howard Street between the 800 block and the 400 block that owns their property, only one, then I'm asking that the special use go with the business. So if the pits go out of business, which they did recently, the next people that come in, they have to come and apply for special use. I'm not asking that they be outlawed. I'm asking that they come here and produce information that shows that they're a legitimate business and that they're not going to create a cumulative effect. And that's what you all do. You make these decisions about what businesses make a district thrive and which do not. And that's what I'm asking. And that's all I'm asking. George can be in the hair salon business for 50 years on Howard Street as far as I'm concerned. I don't want to put him out of business after 2 years. But when George leaves and 3 months later Lillian comes along, special use. Not outlawed, just a special use.
Thank you, Ann. But we were told last month, when we asked whether the special use could go with the business, we were told it could not, or it would be very difficult to regulate. And then if it is difficult to regulate that, then is there a way to shorten this 12-month period, or can you not do that because that's part of the ordinance that already exists?
The 12-month period is something that applies to any legal nonconforming use within the city, regardless of district or what the use is. To change that would be, problematic, and even if we were just to make it specific to some subcategory thereof. And also, it'd be a matter of a new text amendment, not the one that's been proposed for the overlay district. That'd be proposed changes to Chapter 6 of the zoning ordinance, whereas this is a new section of Chapter 15. So it's something that can be discussed, but it's not squarely before the Plan Commission this evening.
Then what about what we had asked? I don't remember who it was up here. Was it Commissioner Ford that perhaps asked it about it going with the business? Somebody, that did come up last month.
It's come up in other contexts, and council believes that it's
Council
proper, I think, and I have cases that go the other way, and I do think we could have a shorter amortization period for one area in contrast to others where there's a particular problem in that area.
But an amortization period could put a successful business out of business.
Well, I think you could shorten the period that it's of abandonment to terminate legal nonconforming use. But I'll let council defend the idea. I think there's an equal protection problem.
I understand the point, but actually the businesses we're talking about don't have special uses at present. They are operating as of right. So the idea of whether or not a special use would attach to the property or to the permittee, in this case, is moot. It's the question that it's a different distinction between a legal nonconforming previously as of use right if the overlay district were enacted with an amortization period or some such, as opposed to ones that already have special use permits in place. So just an important distinction that I think might have been overlooked in some of the discussions.
Any other comments? Yes, Alderman Rainey.
So, Mr. Peters, when you say amortization, do you mean the time? I can use this in two different ways. Amortization for the current business to apply for special use after a year, or a new business coming in within a year.
What I was attempting to say was the period, and now after 12 months, the use is considered abandoned.
Right, I understand.
I think where there is policy justification to shorten the period triggering an abandonment, I'm more comfortable with that than with tying the special use to the user.
But we have tied a special use to a use.
I understand you've done it. It has not been challenged. I think there are equal protection problems. Your counsel has said he could defend it. But
because most special uses we give, I bet, I mean, if you did a percentage, there's no relationship between the use and the property owner other than the lease. And,
well, the difficulty comes, and it was more apparent in the southern states, where most of the law is, when special uses were tied to an owner, then one owner was treated differently than another, not because of the use and the impact of the use, but because of who the owner was. There are some cases upholding it, but I think it's I would be more comfortable if I had to represent someone to represent the challenger to such a thing.
I know you would do a great job.
I mean, I just it makes me worry when you tie it to a user. That now in this case, I don't think any of these users would effectively go to court and challenge it.
The problem, and I know you've talked about this, but the problem is these businesses are not issued business licenses because they have so-called professional license from the Department of Professional Regulation, et cetera. And so we have no other connection to them. So
there might be a way to craft something other than a business license.
We've been working on that for 5 years.
Really?
Yes. It's a big thing of Dolores Holmes and myself. Can't seem to get beyond discussion.
Your light is on?
Oh, I didn't turn it off.
Who else might have
You're looking
suggestions?
at me like you're hoping I'm going to say something.
Well, you resolve things so nicely, so often.
I don't see well, I mean, is part of the issue here that if part of the issue is the 12 months, do we have an equal protection problem if within the overlay zone we shorten the 12 months? Does that get us into another section of the ordinance and tangle us up completely?
I wouldn't go so far as to saying it tangles us up completely, but it certainly does invoke another part of the ordinance. Although I should say that it actually is to some extent already invoked. If you look on the fourth page of the proposed ordinance 2013, it states that this is for legal nonconforming uses or uses rendered nonconforming by the overlay district if adopted as proposed.
What section?
It's the last part of section 2, which 615.17.5, nonconforming uses.
Page 4.
Every lawfully existing use rendered nonconforming by this section 615.7 may continue to operate pursuant to the provisions of Chapter 6 of the zoning ordinance. Chapter 6 is the chapter that governs legal nonconforming uses. This subsection or another subsection of the overlay could be written and brought back to you for consideration regarding a shorter time period rather than the standard 12 months that's applied citywide to something just for the overlay for these types of uses.
I mean, the argument to avoid constitutional challenges, the argument is that the problem in this area is different than other parts of the city, and the longer period of abandoned premises makes redevelopment more difficult. And I think that gets us past a challenge that it's arbitrary.
You're the lawyer, so I'll have to concur with you, but I don't think so.
I mean, it's always hard to predict what will happen in what real judges will do, even from day to day in some instances, but I think there's a rationale that gets us past the challenge that is arbitrary and capricious.
Well, let's say if that holds up, what's the time frame? I'm fine with 90 days. If the point is that you don't want to have these businesses, and we can then, or this type of business, and you can come to the city for the variance to continue, and if that can be done within 90 days, if the city can respond, if that's too short of a time, then 6 months, but I don't see it being longer than that. Otherwise, you're not going to be effective in being able to, I don't think, reduce the number of these businesses, if that's the goal. And you're not putting anybody out of business by doing that. You're smiling at me.
The landlords would have a different interpretation, but I'm agreeing with you. Mr. Steele?
Well, I guess. Well, I'm still bothered by this. For me, I'm still stuck on the part of taking the right away from somebody and making it a special use.
We're not taking the right away.
Well,
you're not taking the right away. You're taking the right of the landowner to lease it to another hair salon past 12 months.
Okay.
But you're not taking the right away of a business owner who wants to convert that from one hair salon to another in this ordinance that's written within 12 months.
Okay. If I want to go to Howard Street after this has passed, and if I want to open a hair salon, I now have to apply for a special use. Okay? And that only will apply to Howard Street as of now, right? Now, assuming that we had 4 hairdressers on pick any other streets that doesn't have a lot of hairdressing salons. Are we going to now go and do the same thing? This is something that the market should be allowed to basically sort this thing out. If those hairdressers weren't making money, they would be out of business. We've also heard that there is only one person that actually owns the building. I think one salon owner that actually owns the building. So arguably, the rest are paying rent. So if they're paying rent, they're not throwing the money away, they're getting something out of it. And I still hold that we should not basically go through the back, take a back route and basically say, no, we won't approve it. If we are trying to limit the number of hairdressers that are there now, what are the chances that if somebody else shows up to basically put in an application to open a hair salon, it will be granted through special use? It wouldn't be. And it has yet to be proven. It has yet to be proven that the hair salons on Howard Street are driving away development. It hasn't, because in order to do that, you have to actually show developers or individuals who are willing to go in there and actually put in something. And you don't have people fighting to get in there.
You make a very valid point.
Accepted. Is this not? Yeah. With one exception. We don't know which is driving which. Do the developers not come in because of the perception of the density of hair salons? I don't know.
That's true. I think when we last met, Richard, good point. But when we last met here, I think there was somebody who was a restaurateur in this town who had also considered doing something over there. You're right in your point, but there may also be people there who the city can actually assist to open enterprises over there without actually having to put anybody out of business or having to make it impossible for anybody to get into the hairdressing salon. And again, if these guys weren't making money, they wouldn't be there. And then this came earlier. Maybe we need to figure out how to tax each hairdressing salon seat to make more money out of that than trying to put them out of business. So let's figure out other ways to make this work.
Maybe the question should come out, does anybody have a strong disagreement that having that density of hair salons is not detrimental to Howard Street?
Can you repeat? Very convoluted.
Well, let me put it a different way. It seems like what was driving this discussion initially was there was a feeling that there were too many of one type of businesses, hair salons, whatever, on Howard Street, that was impeding economic development. Do we agree with that? Is that?
I did not agree with it, but I'm willing to go with the ordinance. The amortization, I was dead set against it. But if people think that this is the case, which to me remains unproven, it was all hearsay, a little bit of almost prejudice. Oh. That's what I heard. But
isn't the position also that these could be any kind of business, but by virtue of the fact, if I can use that word, that they are not really in business, that they are not serious about being in business, and due to the lackadaisical nature of their operation, that is detrimental to development.
Precisely. Going back to Commissioner Scher's question, I would agree that this density of non-performing businesses is a problem. But I think if you had 11 businesses of different types taking up the same spaces and performing at the same economic level, it would be as much a problem for Howard Street as the mere fact that these are 11 hairdressers or 11 astrologers. And if that's the case, then we really have targeted a particular business here, because they happen to be the ones who are there now and non-performing.
I don't think the problem is limited to non-performing. I think a concentration of these types of businesses impedes redevelopment. It makes the area less attractive to other kinds of businesses to go there in a way that banks, there is an effect from the...
No, but I specified, Scott, non-performing. If you had 3 non-performing hair salons and 3 non-performing hardware stores and 3 non-performing restaurants, I submit that the effect on economic development would be just about the same.
I don't think the primary problem is non-performing.
No, my comment was meant to augment the opinion or perception that these kind of businesses also may particularly have a detrimental effect on future development. So it wasn't meant to be exclusive, but I think that's also a characteristic of something which we would want to discourage.
I think the effect is, the accumulation for some types of businesses causes problems. Fast food restaurants would be another example.
Mm-hmm. What is the evidence of that? Is there hard evidence of this? Because, you could have heard in the past that the presence of a woman in a plan commission could distract the other members.
You're very distracting. But I just, in past life, doing work with developers, it was a frequent comment. Have I done a random survey that would be valid under standards for evidence? No. It is anecdotal, solely anecdotal.
We had the owner of Campagnola and Union come in here and speak to us, and he was against this ordinance, said that he didn't find it a detriment to doing business, but that we could do things there that could improve the area, from bike lanes to planters, lights, and things to make it a more attractive area. But by getting rid of I think his quote was, getting rid of the hair salons isn't going to make it more attractive if you don't do other things to the area. He's also said getting the businesses there to clean up their storefronts, cite them for issues with their storefronts. I'm assuming that's been done. Alderman, has that been done?
We have planters, we have bike lanes on Howard Street, just so you know.
In terms of citing the businesses that are eyesores for not taking care of their storefronts?
We have LED lights on all the trees. We have planters that are beautiful. We have the winter plantings now. We have bike lanes. This is interesting. People who are coming down to Howard Street indicating things that are not wrong with it, and then arguing that the wine bar at 629 Howard is going to be a dismal failure and a big mistake. So, I really consider the source.
Mr. Marino?
I have no problem with the 11 beauty shops. No problem. I think 12, 13, 14 going forward is a problem. That's why I'm asking for a special use. There is nothing negative about a special use. We have hundreds and hundreds of special uses in this town. We even have some districts where white tablecloth restaurants are a special use. Gas stations are a special use. All sorts of things are special use. There's a list of special uses in this district, and it's not punishment. It's absolutely not punishment. It has to do with cumulative effect. That's what I'm asking you to look at. That's what I'm asking.
I am not objecting to the special use.
Did you have a...
Yes, excuse me, two brief comments. Certainly in terms of special uses, they're initially heard after notice by the Zoning Board of Appeals. They have to follow several standards for making a recommendation to City Council. City Council, through the Planning and Development Committee, hears that recommendation and then makes a recommendation to City Council, which is the final authority. The other point I wanted to make is, and I'm sure people are aware of this based on the previous discussion, but this is a special area because it's in a tax increment financing district, which has very specific statutory goals in terms of achieving revitalization and redevelopment. So that is an important part of the context here in terms of why we're creating this category of special use, because I think there is a strong indication of problematic situations with the cumulative effect of an excessive number of uses of the type that we're discussing tonight. So we would very much, as staff, recommend that you move forward with a recommendation to City Council, particularly now that the amortization issue has been removed from the revised ordinance that was discussed last time.
Any other comments? Mr. Steele.
Yeah, not to. First of all, I don't claim to be an expert on hairdress on hair salon. I'm not. I'm not. But I think some of the things that are coming here are a bit bothersome, and I think one of it is the whole notion of non-performing. A business that is not performing goes out of business. Also, we have to look at the location of these hair salons and the population that is around that area. These salons have patrons within that immediate vicinity. That is why those doors are open. I still put forth that we should let the market actually regulate this. Making this a special use becomes a backdoor way of actually limiting other people's opportunity. If they're not making money, they will be out of there. Except if they don't pay rent. But if they're not making money, they will be out of there. And I do hear the alderman that there is no, she doesn't have any ulterior motive here. But at the same time, if the issue of cumulative effect is being trumped, is coming up here, then what is the chance that if somebody were to come and say, well, I want to open something like Elizabeth Arden there, you will vote for it? That person won't get approval to get in there. And again, this is to staff here. Look at the nature of the blocks on Howard Street, the width of the depth of the block that we are talking about. What could you conceivably, what kind of enterprise can you think about going in there? What do you envisage going in there? When we cannot attract Trader Joe's to go to the corner of Asbury and Oakton because of the sort of people that live in that area. If we cannot attract people from Evanston to go to this place, then what are our chances of actually attracting anybody to go to Howard Street?
I'm getting offended now.
I'll tell you, I'm going to answer that because I'll tell you, growing up, there were a bunch of restaurants my family and I went to all the time on Howard Street that are no longer there. I'm sorry? They were on the other side of the street. But if they were on this side of the street, we were still gone. The point is going to Howard Street.
Thank you. I wasn't here. So what was on this side of the street then? Do you have any idea?
On this side of the street, you couldn't have alcohol. On the other side, you could have alcohol, so the restaurants...
Mr. Chairman, if I could help with the response to Mr. Steele's question. Certainly when I moved to this area, I lived in Rogers Park in 1975. On both sides of the street, there were a greater diversity of businesses than what exists now. Certainly on the Chicago side of the street, there was a pizza restaurant. On the Evanston side, there was more evidence of hardware and paint stores. The auto parts store that's still there was there back in those days as well. But I think, just wanted to briefly comment on your concern about special uses. It's, all the cases I've seen of special uses considered by the City Council and ZBA, they're very carefully considered, and the application, the applicant are looked at very carefully, as well as the location and the impact on the neighborhood. So one can't assume that a particular application is going to go one way or the other. It's based on the standards, and then based on a very thorough evaluation of the particular use, the applicant, and the context of the site.
Well, okay, go.
Scott's reference to fast food restaurants really sort of lit a light bulb in my head, because I remember when we were working on a downtown plan, and it became very important for us to make sure that the image that was created in the downtown was not one of a standard banal suburban strip center. And indeed, the visions of a multitude of fast food restaurants in areas of the downtown was a very strong one. So I have no qualms about making these a special use.
I have been in suburban areas which are racially homogenous and heard arguments about these kinds of uses similar to what we're hearing tonight. And I don't think it's about race. It may be about class and income levels, but I don't think it's about race.
Well, the argument that I've been making, if I've been making any, is not about race. I just don't think it is proper to take somebody's right to open a business there and make it almost impossible. This is impossible. What you're doing is basically putting an obstacle in a person's way to eventually drive people out of there. Not only that, these businesses don't fall within the category of non-performing because they are there, and they've been there for a while.
But they wouldn't be, if they continued to be there, they would be allowed to continue because we took the amortization out.
Yeah, but then if one closes, right?
And they'd have to.
Okay, let's say we have 5 now. One closes, there'll be 4. Somebody shows up and the person wants to open a hair salon. You will say no.
Within 12 months in this ordinance, they can, though, without applying.
Right.
So without
at the same location.
At the same location.
Yeah.
At a different location, they'd have to get a special use.
Right.
Mr. Chairman, and in going further with Commissioner Steele's thought, let us assume that the number is reduced from 11 to 8 through attrition, and then Elizabeth Arden comes along. Somebody is going to look at the record of all of these discussions and is going to see that one of the things we were concerned about was cumulative impact. And cumulative impact is going to be one of the standards that has to be looked at when we come to the special use permit, and Elizabeth Arden is going to have a problem. So I tend to think Commissioner Steele has a point here, that what we are doing is creating a bar, erecting a bar.
Let me just do a straw poll.
I just want to ask one more question. Commissioner Steele, are there any special uses that we currently have today in the city that you don't agree with?
Well, one of the commissioners asked a question earlier about payday loans, right? I think the whole notion of payday loans don't reflect on the values that Evanston, I think Evanston is about. So I will support something like that. hairdressing salons they don't have any adverse impact on a community. They do hair. That's it. There's a difference between payday loan and hairdressing salon.
I'd like to get a recommendation to the council, pro or con, reporting the arguments both ways on this, so we can have it off our agenda. I'm not sure we're going to, if it either the commission or the staff is going to come up with magic, fully agreeable solutions, and Alderman Rainey will have a chance to argue with her co-council members regarding this.
Hey, Commissioner Steele, you know, I forcefully argued a month ago against this because of the amortization. Forcefully. I was shocked, stunned, blown away that was included in that ordinance. I think as most of us were, especially for 2 years. I don't see how making a special use infringes on anybody's right, because we have special uses throughout the city. And I don't agree with that there's a negative cumulative effect if you had a block of hair salons that were doing great business. So I don't think there is a negative cumulative effect to having hair salons. So I agree with you on that. But I don't think we take anybody's rights away by having an overlay district that has a special use for hair salons and divinatory arts. That's what happens if nobody ever wants to open another salon there. Whose rights are we taking away? Okay? So we're not taking anybody's rights away. The concern I do have is if that's the only type of business that can thrive there because of the community, as you've mentioned, then I'm taking some rights away from a owner of the property being able to rent the space. That would be my only concern. Okay? I don't think we're taking anybody's rights away because nobody's coming to us saying, we want to open some new ones right now or next year or tomorrow or whatever. So I don't think that argument holds water. I also don't, and I again agree, I don't think there's a negative cumulative effect by having a block of successful businesses, no matter what they are. If the businesses, the storefronts don't look well and they don't take care of the property and there's trash all over the place, those are the negative effects, negative cumulative effects that I would be concerned about. Okay, I'll get off my soapbox. So I don't have that big of an issue with having a special use. We've done this throughout the city. And if it's for a goal of trying to revitalize Howard Street and the TIF district, I will support Ann's request of us, because I don't think we are infringing on anybody's rights. Okay, I'm done. Ann, I hope you watch that.
Ladies and gentlemen, does anyone have, if there is no further discussion, are there any motions?
Your light's on.
Yeah. I mean, I was against it when it was first brought up, and I'm still against it. Again, this is not an argument based on race, but there is a place for the market, and this is a clear opportunity for that. The city representative who left today actually stated that she doesn't have a problem with 13 hairdressing salons in the place. She has a problem with 14. And I think enough has been said between the lines to also make it apparent that people really do have problems with this, and people really do believe that the presence of these hair salons in that particular enclave of the city is making it impossible for developers to actually come in. What we don't have is a list of people or developers who are willing to go in. And the assumption that appears to be that is being made here is, if we get rid of the hair salons, developers will come. And it makes sense to actually figure out, I mean, at least the city ought to explore who are the people who are willing to get in there. Last time when we met, there was somebody who came and said, I am anxious to get in there. So maybe the city ought to really find people and say, well, people who are from that community, as Steve is, who wants to do something over there, and provide and forge some sort of partnership with them. If he's a proven restaurateur in this city and he's willing to go there, then, and he doesn't have any issues with hairdressing salons, then is it not in our interest to help another city business person thrive over there? What we seem to be doing, again, the issue is a person's right to open this versus another obstacle coming to a special use committee or whatnot to get an approval for it. Everybody here is free to vote the way that your heart tells you or your head tells you. I'll vote my way, definitely. I don't live in that community. I just don't think it's the right way to go. That's it.
Ms. Puda?
I apologize for being late. Someone stepped in front of the train, and all of the trains from the city were delayed for 2.5 hours. So I missed most of the discussion and probably shouldn't vote. I do have a question, though, because I'm troubled by a sense of this being spot zoning. My question is, are there other places in the city where hair salons and divinatory shops are considered special uses, or would this be the only one? And this may well have been answered. I'm sorry, I wasn't here.
I don't know that there's any. I don't believe there's anywhere else in the city where this subcategory of retail services establishments is singled out. However, retail service establishments are subject to different use restrictions based upon what district you're talking about. For example, in an R1, we're not generally encouraging retail service establishments in general. But as far as parsing them out from other members of the larger category, I believe this is the first time we've done so.
Brand new business?
I don't understand how you mean.
Might be the first time we've done it with an overlay district, as opposed to
the whole standard district,
as opposed to the underlying district. So far as I know, reading the ordinance.
And if I could add a response to your question, again, it's important to consider this as a tax increment financing district, and the fact that the overlay matches up with that district to achieve the goals of that tax increment financing district. So that also gives this, I think, special status.
I understand that, and I really see both sides of the argument. They almost weigh equally for me. I am troubled, however, by the answer to the question, in the implication that, it's just because of the concentration in this particular area that we've decided we want more diversity of businesses there. And, I remember going down there many times over the years to visit restaurants and shops, and there's not the choice that there once was. And I can understand why the alderman, wants to provide more choices. But I guess my concern that this particular type of shop has been singled out in a way they haven't elsewhere in the city would cause me to probably vote no. But I don't think I should vote because I wasn't here for the deliberation until recently.
Is there a motion to make a recommendation to the council?
Mr. Chairman, for purposes of moving this one along, a month ago when we met and we sent this back to staff, I prefaced my motion by saying I was struck by I don't think I used the word disarray, but that'll do, the lack of any clear, A, consensus, B, conviction among us. I am going to move that we not send this recommendation forward to council.
Would you want to recommend against it as opposed to not making any recommendation?
What, send it? Are you suggesting that we send it to them with a recommendation of no?
If that is the conclusion of the majority on the Plan Commission, I think that would be...
No, my motion is to let it die here.
Dennis?
That's not an option. It still would proceed to City Council once it's noticed.
I think
it can proceed without a recommendation, but it also could proceed with a recommendation with whatever additional guidance you wanted to provide.
So the question is whether it proceeds with no recommendation or with a negative recommendation? That's what you're looking for?
I would like the council to have a sense of the arguments in a little more detail than what's usually in the minutes. And if there is I don't know how everyone feels, but it looks to me the majority on the commission would vote no. I mean, we can do it the other way and
Mr. Chairman, I'll withdraw my motion.
Have a motion to recommend it and have it fail, and that's okay too. I make the assumption that our arguments are relevant and might be considered.
Well, if what Dennis has said is true, whether we make no recommendation or we make a recommendation of no, it's going to the council, and the council has access to our record, and I'm sure staff will acquaint them with the course of the discussion, and Alderman Rainey has heard 90% of it. I don't think there's not some veil of ignorance, wrong phrase, Rawls fans, between us and there.
Prefer to take an action rather than take no action.
The intent of my motion, which I have since withdrawn, was to take a negative action.
Well, then why don't you make that motion?
Well, based on what we're hearing from Dennis, whether we take an action or not, this will move forth. It will go to the council. And I agree with Commissioner Ford that the council will have access to what has transpired or the debate that has taken place here. So in this case, Commissioner Scott, even if we were to vote yea or nay, council will still be able to move forward and do what they have to do. And I don't think we need to provide cover. I think council should actually take whatever action they want to take. And they are the elected officials. They are within their right to do that, and I think they should be able to do that.
I don't view us as providing cover, merely getting closure.
But isn't a no decision? I mean, we're clearly not in agreement. I think each one of us can find something in this issue that if you framed it right, we'd vote for it. And many of us are obviously unhappy with the way this thing is going. It seems to me that no decision in some ways is more reflective of where we are than a rejection.
Counsel?
That's maybe a distinction without a difference.
If I could read to you from the zoning ordinance, this is the 6346E, procedure for review and decision of proposed amendments. The E is subtitled Plan Commission Action. Upon receipt of petition, and I'm abridging to some extent here for brevity's sake, Plan Commission shall hold a public hearing. Within 30 days after the hearing is closed, Commission shall recommend the approval or denial of the proposed amendment or the approval of the amendment with modifications, and then submit its written recommendation to the City Council.
So we have to vote on this.
That's what I read as our duty.
So I'll move denial.
I would second.
Is there discussion? All those in...
If I may say, one of the things that has bothered me through this discussion is that we've heard all the arguments, like from Alderman Rainey, we've heard arguments on both sides, that she's bothered by these 11 stores and that she's not bothered by them. She's bothered by number 12 or number 13. I don't know. I've lost count of how many hairdressing salons there are. But she's been on both sides of the argument at every step. I don't buy, I'm on board with Commissioner Steele about this is a market problem. I think that has been the issue from the beginning.
That's what you said in the first
in the
10 minutes.
First meeting.
I said the same thing.
Is there any further discussion? All those in favor, raise your hands.
In favor of the denial.
Denial. 1, 2, 3, 4, 5. The motion to deny passes. Do you wish to attach anything in the nature of addressing the standards or policy issues to send along with that? The standards that might be applicable, the proposed amendments consistent with the goals, objectives, policies of the comprehensive plan. It's compatible with the character of the development and so on. The standards contemplate a map change, which we are not making, but if there is any clear statements that should be made by the majority, we can attach it to our recommendations. Otherwise, we can leave the council to read the record. Seeing nodding heads, we'll leave it to the council to read the record and move to the next item.
Well, they have to watch the record. There is nothing to read.
They'll have to read our lips.
I was concerned maybe I didn't hear accurately in terms of the vote count, but I heard 5 in favor of the motion to recommend denial. I did not hear the rest of the vote.
Is there anyone opposed?
I abstain.
Okay.
Oh, so it's 1, 2.
Is there anyone opposed to the motion?
Yes.
1, 2 opposed.
Opposed to the
What do we-
motion to
hold on.
deny.
To deny.
So who are the 5?
Motion is to deny.
Let's-
If you're opposed,
5, 2, and 1. All right.
Yeah. That brings us to the, where is it? Non-conforming use proposal, PLND 12 PLND 0071. Does anyone on the commission wish to take a short break, or shall we just continue? Hearing no request for a break, we continue. Does the staff have a recommendation or description?
Yes, hopefully this is a bit easier. Staff and the zoning committee has been discussing the issue of non-conforming uses in the city. At this time, we are proposing that currently existing non-conforming residential uses of 1 to 4 families be allowed to have a process to determine whether or not they would be allowed to proceed with the building permit process to increase the bulk of a structure. Currently, the zoning ordinance prohibits any expansion of a non-conforming use, meaning if you have a use that does not conform to the given zoning district, you cannot so much as add an enclosed porch or a garage. Since we are specifying that this would only be for 1 to 4 family residential uses, what it ultimately means is residential uses such as a 100-year-old 2-flat that is now in an R1 single-family zoning district, they currently cannot do anything to the outside of the property that would be increasing that non-conforming 2-family use. We're proposing that there would be a process similar to the minor variance process that would provide notification to all property owners within 250 feet of the property, letting them know that the applicant proposes to make changes, and then a 10 business day waiting period where any of those property owners can submit written comment either for or against the proposal, and after which time the zoning administrator would use a set of standards similar to the standards already used for special uses, unique uses, and variances to determine whether or not that application could then proceed through the building permit process or a variance process if necessary. So ultimately, this would not simply allow someone to do something, it would allow them to proceed into a process.
Are there any instances where they would not require a variance where they would proceed to a permit without first getting a variance?
Yes, if the proposal did meet all other zoning regulations, then from there they could simply proceed to the building permit process, go through plan review, etc., and obtain their building permit.
So if it met the setback and bulk requirements, but was a use that didn't conform, then they would proceed directly to get a permit?
Correct. After going through this new process that we're discussing. So those neighbors within 250 feet would have been notified. There would be that 10-day waiting period. So everyone would be aware that they are moving forward with a building permit.
I understand. Is there discussion?
Quick question for Melissa. So let's say in an R1 neighborhood, right? Let's say somebody has a bungalow and the family, I read what you sent. The family wants to now basically put another floor under. And it's an R1, so I think they can go to 2 floors, right? So in that case, the announcement will go out, right? And then they can just proceed. If nobody objects, they can just proceed as they've always done.
If no one objects and the zoning administrator approves of it by the given standards, then they could proceed.
R1, they can go 2 floors.
2.5 stories or 35 feet to the peak, whichever is less.
It would come into effect if it was height bulk, too many stories, they'd need a variance. If it was a use that wasn't allowed in the zone, then without this, they're barred from seeking any relief through variance or special use.
Okay, I'm getting there. I guess what I'm looking for is that so far as it's conforming, and all I want to do is put a second floor to my bungalow.
And if 2 floors are allowed?
And if 2 floors are allowed, I'm fine.
Or do you specifically mean for a non-conforming use?
No, for a conforming.
For a conforming use, this would have no impact on it.
Non-conforming, right?
Yeah.
Yes.
Yeah.
And this wouldn't apply.
But in what capacity, in what instance will it be? In an R1 community, will it be non-conforming?
There's multiple structures that currently exist that have non-conforming uses. There's people that live in houses where their zoning lot is B2, a business district, or there's multiple cases where there's 2 family dwelling units that are in the single-family zoning district.
My house is an example. The lot is too small. The without expanding the front porch, the entrance was dangerous. But under the current ordinance, it would, if it's non-conforming, I couldn't go in for a variance under this interpretation. So this would allow me to get a variance. It's hard for me to think of examples where involving uses, but I'm sure there are some non-conforming uses.
Mm-hmm. Just as a point of clarification, if I live in a non-conforming house, which I do, should I be part of this discussion since we're going to be voting on it?
Give it to the lawyer.
I
think everybody sitting here probably is, but I'm just.
I understand the concern, and I actually appreciate it. I think it behooves members of public bodies to be concerned about issues of conflict. However, if you were to take that logic to its ultimate extent, no one, including the city council, could weigh in on these types of determinations, because everyone at some level will be asked to weigh in on a piece of legislation that affects the district in which they live, because everyone here is required to live in Evanston to be a member of this commission or the city council.
And we all live in districts? Oh.
Precisely. And so I appreciate your concern, but the fact that you may be eligible to apply for a process that may allow you to apply for another public process does not rise to the level of a conflict of interest.
I think I understood what you said. Okay.
It's a good point, though, Commissioner.
Okay.
I think it's a good idea. I see no reason to penalize owners of properties that, by virtue of sometimes some rather unusual circumstances, are technically categorized as non-conforming. As long as any change that is proposed for them does not, violate the confines or the setbacks of that are already in place, and the process goes forward as a variance with neighbor notification, I really don't see the problem.
The setback could be the non-conforming issue.
Well, in which case,
then
it goes before them for review. But as Scott mentioned, suppose there may be life safety issues that trump 2 feet, a 2-foot extension, into the front yard setback.
I thought you said as long as it's within the setback issues. I'm sorry, I may have...
Yeah, I'm sorry, I misspoke.
Okay, yeah. Sorry. I'm also fine with this. I think it's a good ordinance.
I don't think there's a downside.
Any discussion or motions with respect to this ordinance?
There is one question. Scott, didn't you bring up that you wanted to remove what was the terms? Extraordinary hardship? It's on page 29.
Hardship is gone. Need is there. Hardship is gone, which I think is a good change.
Well, it says evidence of special and extraordinary need you have to prove. That's okay?
I'm not bothered by that.
Okay.
Hardship, I think, was a more difficult standard to prove because of the narrow interpretation the courts have given it in relation to...
Not special and extraordinary?
Yeah, how do you define extraordinary?
More than ordinary.
Yeah, I got that. I don't know. I think that word could probably come out.
Special or extraordinary?
Extraordinary.
How do you define special?
Oh, stop.
Was the obvious next question, wasn't it?
And then we can do need.
Yeah. Nobody else has a problem with it. Nobody else has an issue with extraordinary.
It's an either or, special or extraordinary. It may be that most requests fall under special rather than extraordinary.
Okay.
I
It's an or situation.
I see special as appropriate because if it's a problem throughout the district, an amendment is useful.
I'll withdraw.
I suppose there's an argument to be made about extraordinary.
Well, you have special and extraordinary.
That's right. It's an
Oh, it's and?
Yes.
Yes.
Or.
No.
Ooh, I would change it to or take out extraordinary.
Okay, so I won't withdraw.
Pointing that out.
I think extraordinary probably is too difficult. In the case I gave with my house, the safety problem is an ordinary problem. If you have stairs that are too steep, people fall. And when old people fall, it's bad. Don't quote me on that.
Are you saying you're old?
Young people, too.
When young people fall, it's bad as well.
Oh, they have flexible bones.
Scott, are you calling yourself old?
I was thinking of my grandmother. But special, I think, is appropriate, and I think removing and extraordinary is useful.
Yeah. Not change it to or extraordinary?
No, I think just.
Okay. So with that removed, shall we?
If you wish to make a motion, you.
If I could jump in quickly, also to note something that was not discussed at the zoning committee, we are proposing that in the situation that someone needs a minor variance as well as going through this process, since the processes are extremely similar, the applicant would be allowed to do both at the same time rather than one at a time, taking approximately 8 weeks. The same notification would be given, but instead of sending out a total of 4 notifications, it would be all wrapped in together.
Another great idea from staff.
Wow. Yeah. Cool. Somebody ate their Wheaties.
Or efficient use of staff time, too.
So, Seth, did you want to make a
I'm
motion?
trying to find the where it is in the line. So if you have it in front of you.
It's on page 7.
Yeah, I'm in the PDF, and that's the problem.
6.686.
6.68.
Paragraph A.
Got it. 6.684.
So if you approve the rest, you'd move approval subject to removing the words and extraordinary.
29.
Page 29.
You can use my written.
Excuse me, Scott. I would also point out there's a typo in the date of I believe, in the date of January 14th, 2012. I think it should be 2013, and that comes up in a number of, or more than one place.
All right. Move it to approve ordinance 4-0-13, amending portions of the zoning ordinance related to certain non-conforming residential uses with striking and extraordinary from 6-6-8-6, standard for applications under paragraph A.
There's a motion to make that recommendation to council. Any further discussion?
Seconded.
All those in favor?
Aye.
Aye.
I vote aye. I propose a finding that it's consistent with the goals, objectives, and policies of the comprehensive plan, as amended from time to time, because it allows the appropriate consideration of changes to non-conforming uses which have no adverse impact and therefore is consistent with the economic development portion of the comprehensive plan. It is also compatible with the overall character of the existing development given the standards that are provided, in that it's not a map amendment, so we actually don't have to go to those. It doesn't involve adequacy of public facilities or services.
You want to move that finding? I will move that finding.
Any discussion on the findings? All those in favor?
Aye.
I vote aye. Passes. That brings us to, I think, committee reports.
Yes, committee reports.
Are there any committees that have reports? In his the next meeting of the committee looking at comprehensive plan is on the day after next month's scheduled Plan Commission meeting, and the members of the committee are all looking at the existing comprehensive plan and noting issues that they think need to be addressed where the plan, where there are sufficient changes that warrant consideration of new issues or changes in the plan. Anyone is welcome to come. In his absence, Lenny Azaro was not there at the beginning of the meeting, and we moved and approved election of Lenny and I as co-chairs. It is dangerous not to attend, but he came and agreed he would do that. So you are all welcome to come. It's a morning meeting rather than, no, it's an evening meeting so that we can have a couple hours instead of our usual early morning meetings. I have no other committee reports unless one of you has a report. Anything else that anyone wants to bring up?
Given this is the last meeting of the year, I just remind everyone, in case you haven't already done your Open Meetings Act training, the deadline is the 31st of this month. The link, I think, has been provided to you all. It's also on the Attorney General's website. Once you've taken the training, which should take no more than 30 or 40 minutes, assuming you haven't done it already, please just print out copies of the certification of your completion, hang on to one for yourself, and submit another copy to Dennis Marino, please, for record-keeping purposes.
If we sent them to Craig, I assume that you have them.
Yes, but we're given the changes in staff of late, and that's the end of the year. I just want to make sure that if there are any outstanding, that we still get copies. Yes.
That's all we have, our PDFs. Is there a motion to adjourn?
Motion to adjourn?
All those opposed? All those in favor? Dennis,